motion dated 1st of October 2025, the appellant, who is also the petitioner, raised that this bench, comprising Ogola, Mrema, and Mugambi JJ, do recuse themselves from further hearing on or determination of any aspect of these proceedings. The applicant further seeks to have this matter placed before the Honorable Chief Justice for directions and any subsequent orders deemed appropriate. In the application, which is supported by the affidavit of Joseph Enock Aura, sworn on 2nd of October 2025, the applicant contends that he has been subjected to discrimination by the bench. He particularly contends that the present petition has been irrationally isolated from the consolidated petitions, notwithstanding that it raises substantial similar issues as those in the consolidated petitions. According to him, such isolation amounts to a violation of Article 27, Sub-Article 4 of the Constitution. The applicant emphasizes that it is necessary to have the present petition heard and determined together with the other consolidated petitions, particularly in relation to the issue of an expended bench. He is therefore apprehensive that, owing to the apparent bias of this bench, he will not receive justice in these proceedings. He has cited Supreme Court decisions which we have noted. He faulted the bench for disregarding these authorities and the established jurisprudence which underscores the court's duty to consider consolidation where petitions raise substantially similar issues. In his view, the failure to apply this settled position can only be interpreted by a reasonable and informed observer as an attempt by the court to deliberately sideline him and to entrap his petition within the confines of the res judicata technicality. Following the directions issued on 2nd of October 2025, the bench received the responses from the various parties as well as written submissions which we have considered. The principal grounds advanced in opposition to the application are, firstly, that it was the applicant himself who sought the consolidation of the present petition from Nairobi High Court Petition number E565 of 2024, and that by the orders of 29th of May 2025, the court granted the very relief he had requested. Secondly, it was argued that the applicant has failed to meet the requisite threshold for recusal, that the application was sub judice, and that it proceeded on a misapprehension of the Supreme Court's decision. It was further contended that although the Court of Appeal did quash the order of the Deputy Chief Justice in Gachagua and 5 others, it did not preclude the Honorable Chief Justice from issuing fresh directions reappointing this bench to hear and determine the petitions. Upon empaneling the bench, the Chief Justice was rendered functus officio as of 23rd of January 2025. That is the background of the matter.
The analysis and determination of the application follows. The parameters under which the bench will be called upon to recuse themselves are well settled in law and firmly anchored in jurisprudence. This bench has previously had occasion to pronounce itself on the subject in Constitutional Petition number E522 of 2024, consolidated. In that ruling, we were emphatic that the test for recusal is objective and rests on whether a reasonable and informed observer viewing the matter in its proper context would apprehend bias. We further emphasize that recusal is not to be invoked lightly, but only where circumstances disclose a real likelihood of bias, or where justice would not be seen to be done if the judge were to continue presiding over the matter. We reiterate that position, and we have highlighted the specific paragraphs where the issue is raised. Now, the grounds previously advanced for seeking the recusal of this bench were premised on alleged and disclosed relationships with certain parties to the petitions, which it was claimed might have influenced the court to convene and sit on a Saturday with the intention of assisting one party in the proceedings. We have carefully considered the grounds of recusal raised in the present application against those that were canvassed in the earlier petition. With respect, we are unable to agree with the contention that the present application is barred by the doctrine of res judicata, noting that the grounds then and those now advanced are materially distinct. Accordingly, we shall proceed to consider and determine the present application and its merits. And we find it apt to begin by referring to the decision in Dobbs versus Tridios Bank, where the court stated and emphasized on the importance of a judge to resist the temptation to recuse himself simply because it would be more comfortable or convenient to do so. That decision is quoted quite extensively. I do not intend to quote the entire portion of it. In the present matter, the applicant pleads bias on the part of this bench. To address this contention, we turn to the New Zealand Supreme Court decision in Saxmere Company Limited versus Woolworth Company Limited, where the court again articulated the applicable standard for recusal on grounds of bias. The court held that the test is one of real and not remote possibility rather than probability, and is to be applied through a two-stage inquiry. So the judge must consider first what it is that might possibly lead to a reasonable apprehension by a fully informed observer that the judge might decide the case other than on its merits, and the secondly, whether there is a logical and sufficient connection between those circumstances and that apprehension. Insofar as concerns the informed and fair-minded observer, in whose eyes the potential for bias must be determined, the Court of Appeal in the Bashago and 5 others versus Maingi and 5 others and 80 others, the Court of Appeal was succinct in restating the applicable threshold. A similar position was echoed in Hab versus His Royal Highness Prince Abdulaziz bin Fahd, where the Court of Appeal of England and Wales emphasized 2 critical points. First, the opinion of the notional informed and fair-minded observer is not to be conflated with that of the litigant, considering that most litigants are inclined to resist anything they perceive as jeopardizing their prospects of success, even where such perceptions are not objectively founded. The court also emphasized that the informed and fair-minded observer is to be treated as knowing all the relevant circumstances and not merely those that are publicly available. We do not wish to again quote the entire, that is a page or 2 of that whole determination. Guided by the foregoing authorities, the pivotal issue for determination is whether, in view of the matters advanced by the applicant in this present application, a fair-minded and fully informed observer, one acquainted with all the relevant circumstances, would reasonably perceive this bench as having exhibited bias against the applicant so as to justify recusal. The applicant contends that this bench directed that his petition be heard in isolation, segregated from the other petitions. What he fails to disclose, however, is that on the 23rd of January 2025, this very bench issued express directions consolidating this petition with the other related petitions. The record is clear and confirms the following directions of the court. Direction number 3, that all petitions before the court, that is under cohort 1, cohort 2, and the petitions being today mentioned for the first time, the court went on to enumerate those petitions, including Nairobi petition number E586 of 2024, which is the current petition, are hereby reconsolidated into one petition. petition number E565 of 2024 shall be the lead file. All filings henceforth shall be made in this file. How then did we arrive at the present situation where a petition that had previously been consolidated is now being heard separately? The answer lies in the record of the 29th of May, 2025. Contrary to the applicant's assertions, and in what we consider a demonstration of bad faith and lack of candor to this court, it was the applicant himself, through learned counsel Mr. Harrison Kimanjui, who sought and obtained leave for the petition to be deconsolidated and thereafter mentioned separately from the other consolidated petitions. Counsel expressly submitted that the instant petition raised unique issues requiring expeditious determination by an expanded bench of judges. It was in recognition of this submission that the court reviewed its prior directions. The court concluded that the uniqueness of the petition justified deviation from the general rule and that fairness demanded that the petitioner be afforded an opportunity to prosecute his case without being held in abeyance pending the outcome of cohorts 1 and 2. These directions were not concealed. They were openly given in session, and the rationale for this was explained. For the avoidance of doubt, this bench directed as follows, we quote, "In order to allow the petitioner room and the latitude to fully ventilate his case, and noting that the first interested party has indicated that he will not be participating in this petition, and further noting the previous directions issued by this bench to the effect that petitions not consolidated in the first and second cohort would await the determination of the consolidated petitions in cohort 1 and 2, we review these directions in view of the uniqueness of this petition and allow it to run on its own." Close of quote. The segregation of a petition was not a unilateral act of the court, but rather a direct consequence of the applicant's own request. From a case management perspective, had the court not allowed the petition to proceed separately, it may very well have fallen squarely within the category of petitions required to await the outcome of cohorts 1 and 2. It is therefore our considered view that the fair-minded and informed observer, one who is appraised of the full procedural history, the rationale for the directions issued, and the applicant's active role in seeking deconsolidation would not apprehend bias, mainly because the petition is now proceeding separately.
Accordingly, therefore, we find and hold that the applicant has failed to establish a reasonable apprehension of bias on the part of this bench. The application dated 1st of October 2025 is therefore dismissed. Parties shall bear on course. That is the truth.
Much obliged, yeah.